Good afternoon, ladies and gentlemen. First of all, thank you, Igor, for not only inviting me, but being so persistent. And I am very happy to be back. This is my second time in Dubrovnik. Is a beautiful, beautiful city. My only regret, I can't even see it this time because I'm flying out immediately after lunch. But thank you for inviting me again. And I hope I'll make it up to you next year. If you want me again after what
You'll also make it up and organize a conference in Veneto.
I could try on wine season.
Bring 100 trusty maritime lawyers to taste your wine.
I don't want to go back. I don't want to go bankrupt. Right. Also, it's incredible for me to speak after two demigods of the Hague-Visby rules. We have Michael here, whose knowledge on this matter is just unparalleled, and of course, Ridian. And Ridian, do not worry, I don't think I will disagree with you, but I'm pretty sure you will disagree with me.
That's interesting.
Yeah. All right. So I am dealing as fast as I can with time constraints, basically with the time bar provision of the Hague. This is a great opportunity. It's been 100 years, 101, and the opportunity of sitting down and overview 100 years back and 100 years forth is, I think, non-missable. So what I'm going to do is give you some big thoughts, small, tiny details, big thoughts again, and leave you all, hopefully, with a few questions. My table of contents is as follows: the Lex Maritime 2025. I did promise Eric that I will talk about Lex Maritime every single time I talk about anything at all. The mechanics of time, which I find fascinating, both in physics and in law. What is a time bar? The Hague-Visby rules time bar provision, which is the subject matter, what we're talking about today, and some reflections 100 years on. Now, time bars, ladies and gentlemen, are now part of the structure of international trade. So let me get you back one step and look at the greater picture. Everything in trade is kind of time essential. There is a time sphere of things happening in international trade. And do never forget that shipping is just one tiny bit of the picture. Okay, so before we focus in, let's focus out. And it is so much embedded into maritime law that even the incredible Lex Maritime working group, which I have the honor of being a member, have worked 10 years or 15 years looking at the laws of the entire world and the laws of the Romans, the Phoenicians. We really dug up a lot of history to discover that one of the minimum common denominators of maritime law is that there are time bars in every jurisdiction. And in fact, Principle 25, which is the last, of course, of the principles of the CMI Lex Maritime 2025 is it is common for the positive maritime law to implement the principle that maritime substantive rights of action are time barred if judicial, arbitral, or alternative dispute settlement proceedings have not been instituted or other events having similar effect have not occurred within a specific period. Let's not focus on the wording, because we could talk hours about the wording of this. Let's talk about the principle. The time bar is an embedded element of maritime law across the board, including the counter goods by sea. So it should come as no surprise that the Hague rules have a time bar. The Hague-Visby rules have a time bar. As we shall see, the Hamburg rules have a time bar, and the Rotterdam rules have a time bar. Because all conventions, more or less, have got a time bar. Now let's talk about the mechanics of time. Why is a time bar so essential to the fabric of international trade? Because, although this is technically not true, and here Reagan may actually say, oh, Filippo, it's not right, but it is actually very commercially true that every single time provision is of the essence when we talk about commercial contracts. If it isn't of the essence, legally speaking, is of the essence in the structure of the deal. So we got time of physical delivery in CIF and FOB contracts. Essential. It's a key provision. Now, delivery here, guys, I disagree already with what Regan did say. Delivery here is shipment, so it's before the carriage. Very far away from discharge. Okay? Physical delivery is an essential timing. Time of documentary delivery is of essential timing. Time of all payments is of the essence. Time to assert a claim that something did go wrong is of the essence, as we shall see. And indeed, time to commence legal proceedings is of the essence. So every transaction, so this is the big picture, okay? I am buying a shipload of cargo and I live in a world of time. Every transaction, part of the big picture, has also got its own time provision. And every contract within that sub-part of the transaction has a specific time frame. So the timing becomes very complicated. Now let's only focus on the pathological side, when things go south, not when I have to deliver, I have to take the documents to the bank, when things go south. Under the sale contract, I have a specific time to assert, and I'm coming back to this later, to assert a quality quantity claim on discharge or 30 days, usually, okay? I got the time to assert the marriage, 30, 60 or 90 days from discharge, not load. If it is discharge from marriage, of course, if the CIS FOB loading the marriage is from loading, the end of loading. Time to assert other charges, again, 30 or 90 days. These are all sale contracts which contain provision about when the parties should do something about the transaction, the executive part on the pathological side of the transaction. Then you've got your time bars, 1 or 2 years from delivery, again, sale contract time bars. Indirect time bars disguised as liability clauses, so I will not be liable unless my supplier is liable, and the supplier's time bar is 6 months, so you don't see the time bar, but there is a time bar contract. And then, of course, under English law at least, there is a time limit of 6 years. There's a very significant difference between time limits and time bars, and I'll address it in a moment. Okay, in order to move the cargo, I need a ship, so I need a charter party. Under the charter party, you have a time to assert a claim under the charter party, 30 or 90 days. Sometimes the Hague Dispute Rules being incorporated does make a difference. Time to assert the marriage, which is a specific claim, which has a time frame of its own as far as claims are concerned. You got a time bar proper, again for the marriage and the minor claims. Or you don't have any time bars at all because these are free creatures. Charter parties may not contain time bars at all, and they do all have a time limit because of the statute on limitation. What about the letter of credit? In order to pay, you need a letter of credit. There's another contract with another time structure. So we have time to assert a claim. Article 29 of the UCP 600 gives you a certain time frame depending on the letter of credit. There is a time bar often inserted into the letter of credit contract, which is separate from the UCP. And then again, your 6 years time limit. Mind you, the 6 years time limit may actually, the dies a quo may start counting from different moments of the same structured transaction. And I'm not even going to talk in front of reading about insurance timing, because of course that is essential. Indemnities, and the case we're going to hear from Zoran later was about indemnity, and indeed, of course, our beloved bills of lading, which I deliberately leave last, because in the pragmatic scenario I'm trying to depict, they are not as important or as the other documents, as the same contract, and indeed the charter parties whose performance is necessary for delivery. Now, the mechanics of the timing in bills of lading is also complex. Why? Because they are complex little documents. You know, they're lovely to look at, but then if you actually start studying, you find yourself, as we all, most of us did, stuck for a lifetime to try and understand how they work. As a document of title, actually, they belong to document of titles planet, and therefore timing about these documents is relevant. As a receipt, the context in which they're used may be relevant. They may become relevant as evidence in the performance of a charge party or as evidence in an insurance claim. And of course, again, last but certainly not least, as a contract for the carriage of goods, we have several scenarios. Now, Regan has already touched upon them, but let me just remind you, I have a different order, surprisingly. Common carriage, so English law applies. Well, we learned a lot about common carriage earlier from Michael. Common carriage, English law applies, but Cox 92, the English provision which triggers the application of the Hague-Visby rules is not triggered, so they don't apply to that particular case. You may have the Hague rules applicable, you may have the Hague-Visby rules applicable, you may have the Hamburg rules, which got a 2 years time bar, but of a different nature, or you may have the Rotterdam rules with another different 2 years time bar. So again, the time frame, if you think back at the last 3 slides, is a very complex time frame for one deal, buying a ship of oil, okay? All of that is part of the work which is required by the traders to feed that particular transaction. In practice, so when you are sitting as a lawyer, how does it work? Well, most of us will have a lot of familiarity with this, particularly the last 2 or 3 bits. So you got your loss or damage, which the receiver ascertained at discharge. Then you have a notice of loss, which is sent to the seller and all potential possible carriers in the universe. Just make sure you get them all. Then you notify your insurer, if you have one, that would be a good moment to use it. You ascertain what went wrong, because that is not easy to do, particularly in some cases. Then you attempt negotiating, mostly because the same contract does provide you for a rule that you have to try. Then you issue a letter before action under English law, under our pre-action protocols. You need to write, the lawyers need to write and say, this is the reason why you owe me money. Then you try to negotiate again. You try to ask for an extension the last week, and you hear back on the last day, the answer is no, and then in limine again, you issue proceedings, which you must do if you want to preserve under the Hague-Visby rules, Cox 71 version, English law, you must issue proceedings if you want to preserve, or get an extension if you want to preserve your time. Okay, this is just very pragmatic. Now let's just abstract ourselves and think, what is a time bar? Now for people like me, the first thing I do if I am sitting in the office is a defense. People who work for carriers for a very long time, I think, well, this is a defense. The first thing I want to say, this action is time barred, or this claim is time barred, you're out of time, goodbye. Because I'm going to win for sure, I am dead wrong, but you are time barred. If I'm on the other side, I see it as a constraint. I think, well, I have to rush because I need to get there before the time bar. A little bit more complex than that, because I need to do a lot of things before we get to the time bar. So I am getting worried a lot earlier. So I'm not sitting on my office chair waiting for things to happen. But maybe if you think a little bit more about it, is a way of giving order to chaos. I mean, the situation I just described is so chaotic. If you think you're going to have case after case after case after case, and there is never a time bar, you may find, good grief, my diary will have so many reminders I can't even go home because my diary will just say you have to do something. So maybe it is a good thing that there is an order, there is a rota, there is a wheel keeping us all on our toes. However, if you dig a bit deeper and you think is really, in particular, this Hague Visby time bar, I'll come to the wording in a second. The way I worded this, and I'm just reading because I thought long and hard about it, is a formidable contractual device with which the bearer of a potential future loss gives away its fundamental right to compensation, and the wrongdoer's liability ceases. In other words, the Hague Visby rules, the Hague Visby rules time bar, as stated, is not procedural. It is not that you can't sue, is substantial. The liability of the carrier ceases, disappears. And I start that this is a contractual device because contracts are full of these provisions. But look at what I say a little bit later. When made it into law, when you transform this cessor clause, basically, this is the way I would more appropriately, I think, should be called. If you have a cessor clause and you make it into law, blindly, you are affecting by law substantive rights. This is not a procedural thing that you have to issue proceedings by 6 years, 5 years, 3 years. You're telling me that I've got 1 year, and if I don't sue you, my right is gone, your liability is gone. That's pretty much. Huh? And if you think about it in this way, which isn't, but look at the Athens Convention. They got a 2 years time bar after which you can't claim. And this is death or personal injury we're talking about. So you have a car accident, then you can sue after 10 years. You do some criminal stuff and you can be sued basically forever unless you're Italian, apparently the law there is different. But you have an accident in a ship and there's a very short time to make the claim, to realize you have a right and make the claim. This is about the Hague Visby rule. So let's look quickly, because time is always tight, at the wording. Let's forget for a moment. It is the clause is quite longer and it's divided into 2 bits, and this is the case for the entire Maritime Conventions we are going to be looking at, but I'm going to focus only on the actual time bar. So not the time to make a claim, but the limit you have to make a proper to commence proceedings, basically. So there is the time to assert a claim, which you can read yourself, and there is a time bar provision proper, which says that subject to paragraph 6 bis, the carrier and the ship shall in any event be discharged from all the liability whatsoever in respect of the goods, unless suit is brought within 1 year of their delivery or of the date when they should have been delivered. This period may be extended if the parties so agree. This is different from the original version of the Hague rules. I think it was mentioned before, where it was in a way simpler. It simply said, in any event, the carrier shall be discharged from all liability in respect of loss or damage, unless suit is brought within 1 year of their delivery or the date when they should have been delivered. The shorter it is, the nicer, as far as I'm concerned. I like short and clear. Hamburg rules is different, very different, because it doesn't talk about the liability being discharged. It talks about, like most of the other conventions, the action. So it's a procedural time bar. It's not a substantive time bar. Any action relating to carriage of goods under this convention is time barred if judicial or arbitration proceeding has not been instituted within a period of 2 years. So look at that. Longer, quite frankly, bigger. Okay? Any action relating the carriage of goods is very wide, very broad. So bigger, longer, but procedural. Very different. Rotterdam rules, no judicial or arbitral proceedings in respect of claims or dispute arising from a breach of an obligation under this convention may be instituted, again, procedural, after the expiration of a period of 2 years. So longer, wider again, because it's everything in the convention, so very much wider and broader, but still procedural. Which means that why procedural is so important? Because then you fall back into the procedural code and rules of the country, the next fora, which may allow other ways of expanding the period. There are exceptions, there are possibility of doing things so that 6 years or 2 years in this case may actually grow. We don't know, there is no uniformity. That's the drawback. You know, you got 2 years, but you may be able to buy some more time due to the application of the lex fora. Now, we've seen the provision and we've seen how the provision has developed into the hands, into the pen of the draftmen of these conventions. You've seen The Hague, Visby, Hamburg, and Rotterdam. The English courts, what have I done? Sorry. The English courts have done another thing. I'm talking about English law, of course. Have interpreted these rules, in particular, I'm looking at this particular provision, in a way which has helped often carriers, like we shall further hear in a minute. I have chosen some of the wordings, okay, in the provision. So, for example, the carrier and the ship, this wasn't there in the edition in the Hague rules. It has been introduced. And what is the meaning of this? Well, the meaning, at least the Star Sin in the House of Lords, the Star Sin said, well, actually, it's about if somebody tries to get to the carrier through an action in rem, well, no worries, because the time bar applies. In any event, okay, the word in any event has been interpreted, to no surprise, I have to say, in the Captain Pekko Voivoda and indeed in the Giant Ace, on which we're going to hear a lot in a minute, to mean in any event. So the limitation applies in any event. So the time bar applies in any event. All liability whatsoever, I'm going to repeat what has been said before, but again, limnos, Giant Ace, whatsoever means even bigger than all liabilities.
Sorry, Filippo, we are approaching the time.
I am coming. In respect of the goods, including economic loss, was already said in the limnos. Now we heard a moment ago, it's growing again. And again, other details which have always clarified in an extensive way the protection which this gives to carriers. But so whether we like it or we don't like it, whether we agree with it or we don't agree, the trend is longer and broader. Whether you look at it as a draftsman interpreting a written provision or as a lawyer who is using English law to defend find claims. What is more interesting to me is that this notion of a substantive cessor of liability time bar, this thing which has been used in the Hague Visby rules for 100 years, has spread like wildfire in the rest of the transaction. In fact, if you look at the major contract for the sale and purchase of oil, the GT&Cs, they all have provisions which do not affect the time limitation of actions, they do affect the substantive liability. So you might have 30 days cessor clauses, 60 days, 90 days, 6 months, 1 year, 2 years, and a lot of them apply to bits and pieces of the contract. This is now part of the way the job is done. And that is under attack in some ways, first from new conventions, which seem to have steered away completely from this cessor of liability, going back to a procedural time bar, which in my view flies to the face of uniformity. And because it becomes also longer. So there is a longer, broader, and procedural transformation of what is with time bars we have been looking at in the last 50 years, I'd say. But there's also some strong defense from the courts who try to stick to the Hague Visby and try to stick it as narrowly as possible. I think these time bars, let's look a bit into the future for a second. These time bars are there to stay. Okay, and this substantive time bar issue is there to stay even more in international trade. I think the Hague rules, and here some of you will disagree, are here to stay also. Okay. And they're not here to stay forever. They're here to stay until the system of international trade works the way it has worked so far. It will be too much of an effort to change, since we are about to revolutionize trade completely with the use of AI, ships, mass, autonomous stuff all over the place. So I like the shoehorning thing. I think we're going to learn and keep leading after 100 years. We have learned how to shoehorn the newbies, the new developments, the new life which is coming to the international trade system into the old conventions. And I think we can shoehorn everything which is happening in these time bar provisions, which are gonna, I think, stay with us for a long time. However, I think we're not going to have another convention containing time bars, because probably the time bars are already so much into the system that they will be all contractual, even if you take them away from convention. So these are my thoughts. Thank you very much.